Good afternoon. My name is Renee Castillo de la Cruz, and I'm a staff attorney at the Texas Children's Commission. On behalf of the Children's Commission, I would like to welcome you to today's webinar, which is focused on trial skills for child welfare cases and is entitled Making and Responding to Objections. This presentation is provided by Rob Galvin, attorney at law, and Drake Mikeska, managing attorney for DFPS Region 8. They will focus on the importance of making proper objections under the Texas Rules of Evidence and will include strategies for when and how to object, how to respond to an objection, and what to do once a ruling on objection has been made. A PDF copy of the presentation for this PowerPoint is available for download on the Children's Commission's on-demand MCLE webpage, and a link to this page was included in today's webinar reminder email. For those watching the live presentation, the Q&A feature is available and this webinar and questions will be addressed at the end of the presentation if time allows. Additionally, the MCLE course number will be provided at the end of the presentation. For those watching the webcast replay, you may email cctraining@txcourts.gov for self-reporting information. It is now my pleasure to turn it over to our co-presenters, Rob Galvin and Drake Mikeska.
Hey, good afternoon. Rob Galvin is my name, and so we're here to hopefully talk about objections and kind of provide a little bit of guidance on this critical part of what we do in court. So I'll turn it over to Drake.
Thank you, Rob. Good afternoon, everyone. My name is Drake Mikeska, and I'm going to start us off. So, Renee, if you would take us to our next slide. We're going to start off with actually making the objections, right? So, why would someone want to object during a hearing? Well, first and foremost, an objection is just the formal protest to try to keep evidence out, right, from evidence being considered by the fact finder. And we want to make objections for a couple of purposes. Number one is going to help build your case, possibly for a stronger trial, right, by keeping evidence away from or out of the consideration from the fact finder. And number two, if evidence is improperly admitted, then you're going to be able to preserve that issue on appeal under the Texas Rules of Appellate Procedure, and making sure that you're protecting that record in a lot of these cases becomes vitally important. All right, so Renee, if we go to the next slide. With an objection, they can be written or oral and can be raised at various increments or various points along the way, right, as far as our cases are concerned. So you can do it through written motions, you can do it during discovery requests, during deposition, and then in any sort of hearing that requires the fact finder to make findings, those sorts of things, and obviously during trial. I think Rob and I both agree that the biggest thing is you need to know your rules, you need to know your objections. And if you don't know the rules, you don't know the objections, you're not going to be able to effectively represent your client in court. And so having an intimate knowledge of the rules and of the objections is vital here. Bring a cheat sheet. I'll admit that I have cheat sheets with me every time I go to court, whether it be Zoom or in person. My personal favorite, and I'll just give a plug to the Children's Commission here, is their the help or the the toolkit for attorneys representing DFPS. I know they have one for parents as well. So I take that with me every time I go to court, and I have it available. It's actually sitting on my desk right now. So bring that cheat sheet, have it handy for you to be able to reference easily. And then finally, plan, right? Planning for evidentiary issues, especially attorneys for the department, whenever you're introducing evidence, is vitally important. Those big pieces of evidence that you're maybe going to have issues getting in, spend some time in your trial preparation to be able to know how you're going to get that in, have multiple routes available of how you can get it in if you're not successful in one of them, and just be prepared for those potential issues.
Yeah, so
Rob, anything you want to add to that?
Yeah. So these are big concepts that we're talking about here, and we're going to go into more detail as we go through the actual webinar and the presentation. So just want you to be aware that these are really big concepts that we're talking about, and we'll talk a little bit more about how to do these things. And this presentation's really kind of the focus is trial objections, but as that first bullet point reads, I mean, objections are also in discovery. Different jurisdictions do, different counties do discovery differently in CPS cases, but be aware that that's a place that you can find objections to or make objections. That clearly in any other evidentiary type of hearing, whether it's a motion or it's a merit setting, that type of stuff, you can also do objections there. And so, but we'll get more into the details of these bigger concepts that we're talking about as we go through the slides. So that slide that we just saw was the one that went really fast, objecting to witness testimony. So now we're going to focus a little bit about what happens when a witness is actually testifying. So imagine that we're now in court and there's a witness on the witness stand providing testimony, whether it's a merit setting, whether it's a temporary orders setting, whether it's the first, a 262 hearing, whatever hearing it is. So we wanted to focus on some of the common objections. And one of the things that we keep going back to is know the rules. So we've inserted what the rules are, at least where you can reference them. So one of the most common objections clearly is the hearsay objection. So you find that under 801D and 802. So be aware of the hearsay objection. And I think that comes from both places, whether you're going to object to hearsay or you're going to provide testimony from one of your witnesses that can skirt right on that hearsay situation. We'll talk a little bit about how to overcome hearsay, but be consciously aware that hearsay goes both ways, that you have to be prepared for, whether objecting or responding to hearsay. Another objection is leading, so suggestive leading type of objections. The rules there, 403 and 611C, which is more of a form objection. So one of the things that we see sometimes is people object to leading when they're doing, when someone's cross-examining somebody. So just be aware that in cross-examination, you can lead. So don't be so eager to make a objection to leading when someone's cross-examining a witness. And a cross-examination is not necessarily that somebody else called. It could be an adverse witness, right? So if CPS calls the parent to testify, that parent is an adverse witness to CPS. And so be consciously aware of that. Do you have anything to say on that hearsay and leading parts of Drake?
Right. So I agree that, with the direct examination of a party that's, opposed to your position, you're allowed to lead. The other thing I would say about leading is, remember that the leading questions suggest the answer. And so if a question is a closed-ended question, a yes or no question, that doesn't necessarily mean that it's leading. Right. It's not uncommon for especially attorneys for the department to ask closed-ended questions, right, and then follow it up with a more open-ended question as they get more information out from the witness. So just because it's yes or no doesn't necessarily mean that it's leading.
Okay. And then moving on to narrative and non-responsive, they're almost cousins to each other. So the way I see it is the narrative objection is when someone's on direct. So it's really the attorney that's opposed to the direct examination, right? So it is the witness who goes on and on and on about providing a narrative to the direct question. You can have narratives on cross also, but it's really, that's where I see that objection, is when there's a question that's posed to that particular witness, and that witness answers the question and then just continues to provide more and more information. So that's really the narrative objection that would come from the other side, saying objection narrative. The non-responsive objection typically is when you're cross-examining somebody and you ask them a question and you want an answer and they don't respond accordingly. It's always kind of strange. It happens. It's strange when an attorney calls their client up and the client starts answering the question, and the lawyer says objection non-responsive, so objecting to their own witness about them being non-responsive to the question. So like I said, I kind of see those two objections as cousins to one another, applied in similar situations, but from different perspectives of the bar at the time of the question and who the witness is. Drake, you want to add to that?
No, I personally, I don't really object to narrative questions a whole lot because, if the person is giving me a lot of information that I don't necessarily already have or already know, then I'm just going to let them keep on talking.
And the more they talk, the better sometimes, right? So now when we move on to relevance, irrelevant. So is the question or the answer relevant to the subject matter that's before the court? That happens quite frequently when someone starts talking about somebody's second cousin that did this, or they had a friend that was involved with CPS. That's where you get into your relevance objections and can shut that down pretty quickly. Witnesses lack personal knowledge. That's a favorite one. They don't have the personal knowledge of speculation. They don't know. Typically, that's where the instruction from the judge comes. Testify as to what you do know or what you saw, what you heard, those type of things. And then speculation is when someone's completely speculating. If you're going to create a hypothetical and you're asking about a hypothetical, make sure your question is framed as a hypothetical so you can somewhat fight against the speculation. But if you ask a question like, how did James feel when he found out that his children were removed? Unless James had a conversation with somebody, or unless the person was aware that James pulled their hair out and gnashed their teeth or something because they saw it, they're going to speculate to the feelings that was going on with James. So, be aware of that. Experts can speculate, but their speculation has to be based on, and this is your foundation questions, right? It has to be based on their expertise, their science, their application of the facts, and the testing and the methods that are widely accepted in their field and their area of expertise to then be able to speculate. You may see some of that with psychologists. I think what I see a lot of times is objection speculation, and nobody goes back to really frame the fact that the expert can actually speculate because they don't build that foundation as to why this is what the future may look like for this person. Drake, anything to add on that?
No, as far as the speculation is concerned, just make sure, like Rob said, that if it is a hypothetical, that it's really clear that it's a hypothetical in the questioning itself.
Renee, we could pull the next slide. So staying with these common objections, so calls for a legal conclusion. So we see this a lot, right, in CPS cases. It's maybe the direct examination of the caseworker that mom doing this, doing that, doing all these other things. Is that endangering behavior for to the child? And so that cuts really close up to that legal conclusion, because endangerment, the word endanger, there's actually, if you're doing a jury trial, there's a definition, right? And your jury charge that you like to put in there that says endanger means blah, 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 that we get from the case law. So be careful with that. And especially really, you're going to be defending as a parent's attorney, you're going to be defending from those legal conclusions. Best interest is one that sometimes comes very close, instead of being, lay witness opinions can be done. That's 701, but that comes close to a legal conclusion. So just be, have your ears wide open when that testimony is going on, and be ready to make an objection there. I don't necessarily see it as much from the other side where, from the department side, objecting to someone that's, a pro-parent, or, fighting against termination, when, making that type of objection. The ask and answer objection. So this is a very common objection, and at least in the trials that I have. And so as I understand the rule, the ask and answer objection is a good objection if Rob asks the witness that question and goes back to the question again and the question again, and really it's developed so we don't try to trip up witnesses and get them to answer something differently, and we're being shady lawyers. So if Drake comes along and starts asking questions, and he asks the same question or a very similar question to I ask, I sometimes will hear someone jump up and down and say, objection, ask and answer. As I understand the rule and the application of the rule, Drake's got every right to ask whatever question he wants. It wasn't asked during his direct or cross-examination, his examination of the witness. And that's where the application is on ask and answer, is that it's not the attorney that's asking the question that asked it before. So be mindful of that. Anything on those two, Drake?
No, not on those two.
Okay. So beyond the scope, that's an objection that I honestly don't really quite understand to some degree. Understand that beyond the scope can occur that a witness has come to testify like an expert. They're testifying to stuff that they have not, it's not been established that they have expertise on. And so there's a lack of foundation there. And so it may be outside the scope of their expertise. A heart doctor, you get these in cases with child injury, right? So your ortho may be able to talk about the bucket fracture, but won't necessarily be able to talk about the hemorrhaging in the brain, right? Because that's not their area of expertise. That's not where the application is at. So where I see it sometimes, and where it's been used somewhat unsuccessfully against me, is when I'm asking a witness a question, and so there's an objection to beyond the scope, and I'm a little confused, and I'm like, I don't understand that. And they say, well, it's beyond the scope of the direct examination. So that doesn't apply in Texas court. So the rules are very clear that in Texas, we have a open cross-examination. Federal court, it's different, but in Texas, we're allowed to cross-examine on any relevant information that exists, and then we can garner from the witness. So, I think we're going to talk about that one a little bit more when we go down into the responses to objection, but just be careful when you're making that objection. And then the other one, assuming facts not in evidence. Now, this is, to me, a very, very powerful objection. It's also a very tricky objection. Those of you who have tried these type of cases know that there is a lot of testimony about things that no one else has testified about. And so you can have caseworkers, you can have parents, you can have, CASA, you could have therapists, you can have all these people testify about events or facts that they perceive to be true that no other witness has provided testimony for, and these are not fact. And sometimes it's in the actual questioning itself, right? So you're listening to that questioning that's coming along, and so be prepared for that, because I think these cases, more than any other type of civil case I've ever tried, they're more rife with that type of testimony or questioning, especially when there is when say a parent who's actually lived the facts of the case hasn't testified or hasn't presented that evidence yet. And so there's nothing there for the caseworker to kind of hang their hat on, that these are the facts that have been brought in. So anyway, anything you got to add on those last two there?
Yeah, I would just say with the assumes facts not in evidence, one of the things that we do, especially if you've been practicing this area for a long time, is we're familiar with these cases from start to finish, and in a lot of cases the judges too. And so if you're at final trial, you can't rely on the fact that the caseworker testified something in a permanency hearing or in the status hearing. All of that evidence has to be presented during the course of the actual trial. And so practitioners just need to be aware of what is being presented in trial, and making sure that evidence is actually brought in, and they're not relying on something that happened historically in the case.
Yeah, and I would add to that, that's a really, really good point. Some of y'all know that we do the trial training skills program, and I think it's now in its 12th year, somewhere in that neighborhood of time frame. One of the reasons that program was created was because the appellate courts were looking at situations where there were bench trials, and the record would read, well, Judge, we don't need to talk about all these things that happened before because you've been the judge on this case during all the permanency hearings and you're well aware about what this family does. So we're just going to cut it, to they haven't done anything, and and the judge goes termination, best interest. Then they get up to the appellate court, and the appellate court wouldn't have a record at all as to all these events that people have knowledge of, at least in the permanency hearings or in the status hearing or whatever it was, but wasn't part of the trial record. And so that's one of the reasons why the training program, trial skills program, was created, because the appellate court saw that issue. So really important to maintain, create your record, and to be well aware that those facts that were part of some other hearing are not part of this particular trial prospect. Next slide, please. Okay, so kind of some buzzwords, things to pay attention to. Personally, I don't think you can do this kind of work if you're not really listening. I think that's the most important skill for a lawyer during a trial, is to listen to what's being said and what's being asked. So here are some buzzwords that should get your radar up into be in a position where you're ready to jump up and to make an objection. Is it possible? That's your speculation. Is it conceivable? Speculation. What did he say? Your hearsay. Where did you learn that? Where did you learn that from him? Did he agree with you? What did he conclude? Those type of phrasings are things that you should be paying attention to. From the witness, well, I was told, that's, one that you're like, okay, wait a minute. That kind of stuff. Or the witness says, I wasn't there that day, but I was, what's coming after, I wasn't there that day, or I didn't see it, because they wouldn't be able to say anything else unless somebody told them something. So just be aware of those catchphrases that, that make you think that the next thing that's going to come out of somebody's mouth is going to be objectionable. Next slide.
So here we have a list of objections that we think that just really aren't used enough through the course of litigating a CPS case. First is leading, and we touched on that earlier, right? So just because it's a yes or no question or a closed-ended question doesn't necessarily mean that it's leading, but something you should be paying attention to is, wouldn't you agree? Or you ask the question and then say correct. All right, where again, the question itself is implying how the witness should answer the question. With regard to narrative, again, sometimes we ask questions that just allow for the witness to, give a monologue. And sometimes it's beneficial to allow them to speak and just allow them to keep speaking, because you keep getting more and more information. They're offering it up without having to ask another question. But sometimes it can also be, detrimental if you're the attorney that's sitting there listening to opposing counsel, cross-examine or even on direct a witness, and you're not objecting, right? Because you need to make your opposing counsel actually do the work. I will instruct my witnesses all the time, right? Don't offer up something that's not asked. Make the other attorney pull the questions and get the information out of you. Don't just offer it up. Relevance is another question or another objection that we don't really see used enough. Again, as Rob stated earlier, they start testifying as to what happened in their cousin's CPS case or whatever the case may be. If it doesn't pertain to one of the issues specifically before the court, in this case, then object to it and keep it out. And then next and finally is argumentative. I will use this objection quite a bit and really try to protect my witnesses as much as I can. If the attorney or opposing counsel is making some sort of sidebar comment, intended to attack the credibility of the witness or something along those lines, then I'll object to the argumentative aspect of the question and force them to rephrase. So next slide, please. So the next thing that we're going to touch on is objecting to hearsay and statements in affidavits. So whenever you're objecting to hearsay in affidavits or any other document for that matter, you want to make sure that your objection is specific. You can't just make a general hearsay objection. Whenever I will draw those general hearsay objections to documents, my common response is, Judge, they need to be specific. They need to tell you specifically what statement in the document is being objected to, and then deal with those statements specifically. If those hearsay objections are being overruled or they're coming in, you might want to think about offering a running objection. All right, so for running objections, you just have to make sure you do a couple things first. You have to make sure that you clearly identify the source of the evidence that you're referring to. So if it's a medical report, right, and there hasn't been anyone to come in and actually authenticate the report and those sorts of things, make sure you clearly identify the source of the evidence and then the specific subject matter that you believe is objectionable. As long as you do those two things, that it's specific, it's unambiguous, and you're identifying that subject matter, then the running objection should protect you and should protect your record moving through the course of that hearing. CPS affidavits it's pretty common for them to have hearsay statements in them, right? Because investigators talk to other people. They talk to the parents. They talk to grandparents, aunts, uncles, teachers, doctors, law enforcement officers. They talk to a lot of different people. A lot of those statements and the information they learned during the course of that investigation or that case is going to be contained in that affidavit. And so if the department's asking to, introduce the affidavit as a document or as into evidence, be prepared, right, to object to all of those statements. And then attorneys that represent the department, right, you've got to be prepared for that as well. Even though I know my affidavits have a lot of hearsay contained in them, I will make sure that I have each of those witnesses available to testify. And if I don't have them available to testify, then I'm not going to go into, those specific contacts and everything with my investigator. Anything you want to add to that, Rob?
Yeah, so on the affidavit part of it, really, as we said earlier, part of the reason that you object, aside from protecting the record, is to build your case, right? And so to try to put your client, whoever that may be, into the best position possible for a verdict or a judgment in your client's favor. So there may be things in the affidavit that they're hearsay, you don't want them to come in because, as a matter of, rule and policy, you're like, okay, these shouldn't come in. But do they hurt your client or do they help your client? And so, recently I tried a case in where the affidavit was clear that my client was initially the non-offending parent, and in fact did not have the allegations were not against my client. The child was born in the hospital. The investigator was clear that in the 3 months of trying to offer services and contact people, that my client was cooperative and my client was friendly. There were no issues with him, no concerns. There was no drug testing required because there were no concerns about him doing anything. And then ultimately, when the FBSS or COS case failed, the new affidavit made some allegations against my client that he was neglectful supervision, although my client had been asked to move out of the house so he was nowhere in the presence of the child, living with the child. And ultimately the investigator there testified that was ruled out. So here we had a whole CPS case with about 6 months of investigation. And in it, the affidavit really painted my guy as a very cooperative guy that no one had any concerns with. And the one referral that came was a rule out. And so, ultimately he was successful at trial. And so, you got to make that decision. Is this something that I want to object to, or even though there's hearsay in there, or does the hearsay actually help my guy out? And so, just, be aware of, should you or shouldn't you object? So I hope that helps a little bit. I guess next slide.
All right. Yeah.
Okay, object to leading. So you want to make sure that the story is being told by the person who's testifying. And so this is one of these weird things, right? Because you'll hear a lot of presentations say, when the lawyer leads all the time, it's the lawyer who's testifying and it's not the witness, and people care about the witnesses testifying and not what the lawyer says. And you can use that argument on closing argument. And that's true, but also if leading is occurring frequently, there may be a picture that's being painted that might not be the most accurate picture from your client's perspective in your analysis of the case. So be very, very aware of whether those leading questions are detrimental to your client. I lead sometimes because we are on a time crunch, and we know that we're on a time crunch. And so I think there's a little bit of flexibility there, but I'm just going through some basic stuff. And then, if I get an objection on leading, then I can turn it around and re-ask the question. Sometimes I'll just re-ask the question without a ruling. And at that point, especially with the jury, it starts looking kind of petty when the question is like, you just turn the question, change 2 words on it. And they're like, why do we have to go through all that when the answer is what the answer is? There are some instances that you see 1, 2, and 3 here on 611 that discuss what is not a leading question. And so a lot of these preliminary matters and stuff like that, undisputed matters, sometimes those lead to those objections about leading. And so, while we keep saying know the rules and how to apply the rules, that's the next part of it, know how to apply the rules, is you want to appear competent in front of a jury and in front of judges too. But it's really more, the jury is going to be, if you're a kind of person who's being overruled a lot or objections against you are being sustained, at some point they'll start losing faith in you. And if they lose faith in you, they start losing faith in your client. So make sure that what you're going to do is going to be worth doing it. Next slide, please. Unless you got something to add on that, Drake.
Yeah, no, I think just the strategic nature of objecting. I tell my client all the time that I'm playing chess in the courtroom, right? And I'm having to make very strategic decisions. And so sometimes I might not object just because strategically speaking, it's not the best thing to do.
Okay, common objections to exhibits. So here are some objections to exhibits. So the rule of optional completeness. So there is a guy who a lot of you know. I'll make a plug for him, Mark Zuniga. He loves this objection. It freaks everybody out because no one knows what the objection is. And they're like, oh, wait a minute, I've seen him use it way, way too many times. So be familiar with the rule, its application, and sometimes making the objection itself, the fact that it's not a complete, record that's trying to be introduced. Sometimes that and the best evidence objection, right? So those are the things that may trip people up. So be aware of that objection, understand, how it can be applied. What you really don't want is somebody carving out just a little piece of the evidence and presenting that. You see that sometimes like an appellate briefing where they'll put the first part of the sentence in there, but they leave out the however part that comes next to it. So be aware of what your evidence is going to be and what they're offering. And so be prepared to object that it's not a complete record. Lacks proper foundation. I mean, that's pretty self-explanatory. Hopefully by now is that everything that comes in, there has to be a foundation applied. The predicate has to be established. Sometimes it's not. But we do some seminars and training on predicate and laying the foundation for exhibits. I think there was one back in November. If you're unfamiliar with that, go do that webinar and do that training. You want foundations to be there. sometimes as a parent's attorney or any attorney, quite frankly, if you get objected to on foundation issues, it's easy to establish the foundation. I call it the dog and pony show. And if they want you to go through the dog and pony show, then you do it. And oftentimes it's like one of these rituals that takes place that, quite frankly, juries are like, why do we waste time going through this ritual? Because this evidence is coming in, right? So not properly authenticated kind of falls in the same boat with that. Make sure that whoever is offering that particular piece of evidence can authenticate it. Typically, in our cases, a lot of this stuff is done beforehand, right? You have your pretrial hearings. The judges are always, I've not met a judge yet that hasn't said, have you exchanged exhibit list? Have you gone over the exhibits? What is being offered? What's being agreed to? And you usually have these type of discussions, prior to a trial that's a bench trial, or you have them, even in the mornings before you bring the jury in to talk about new exhibits to come in. So make sure they're authenticated. Relevance is always an objection. So make sure whatever it is that they're trying to bring in is relevant, and then make sure that we talked about the affidavit, but make sure there's not double hearsay, police reports, things like that are in the document. And we said look at 805, because 805 basically says, if there's a hearsay exception within the hearsay and that applies to both levels of hearsay, then that's good evidence. Can you apply the exception to each different component of hearsay? And then the last one is it's prejudicial. It outweighs the probative value. I think we see some of that. I mean, I have, when we're talking about graphic photographs of injuries to children, we don't necessarily need to see autopsy photos. We know the child died. We don't need to see sane photographs of a child. We know they were, molested. So I think, to me, that too is some of the bigger issues. Sometimes you get some of that stuff though when you start thinking about like social media, Facebook, things like that. You may have a client who posts something that may not be illegal. There's nothing wrong with owning guns in the state of Texas. But your client, being portrayed as some crazy person who's got a gun collection and is posing with their AR. And what's the probative value of that, the fact that he owns a gun, right? Especially if there's not a violent predisposition for that guy or a history of that. So be aware of those type of things. Drake, you have anything to add on this slide?
No, as far as the authentication stuff really is concerned, again, I think being prepared prior to your hearing, and knowing what the predicate is, again, having those sheets available. Like I said, I have my toolkit available with me pretty much every hearing that I go to. That way I know that I can hit all of those points that I need to whenever I'm authenticating documents. But again, you can address a lot of that in preparation.
All right. So our next slide, please. Staying on the theme of exhibits, one of them is contains inadmissible matters, right? So the document itself, the exhibit itself, photograph, whatever it may be, may have things that are inadmissible, mentions prior convictions, drug test results, etc. So here's the issue with our cases. So the issue with our cases, and we can look at Rule 609 and the Taylor case is cited in here for y'all. So admissibility for cases, right? Because we have this statute, the E ground and the D ground, E in particular, that talks about a course of conduct that is committed. So a course of conduct, and the case law is clear, is not a one-time event. It's a period of time, right? We got the Boyd decision from the Texas Supreme Court that tells us that the endangering behavior does not have to be directed at the child, that the child does not have to be present during the endangering behavior. In fact, the child does not even have to be born during the endangering behavior. So that opens up that's what Taylor basically says. That opens up a wide latitude of what type of behavior that actually come in order to show that course of conduct. So Although in other civil litigation, you may not be able to talk about the DUI that occurred 7 years ago. In our world, that's part of the course of conduct that occurs. You may not be able to talk about the multiple arrests without convictions that occurred, but our case law has said just being arrested itself is an endangering behavior that affects a child's emotional well-being. So be aware of, there are things that might be able to come in that normally wouldn't if you were doing a divorce, you were doing a probate matter, you were doing a car accident, whatever whatever else it may be. But in child welfare, it's a little bit more, lot more latitude for that type of stuff to come in. And then the last one is the violates the best evidence rule. So, not a common objection, but every once in a while someone throws it out. I've talked about Zuniga doing that. It freaks people out because they're not used to dealing with it. But really, the bottom line is read the rule, and then, a copy is good enough, right? So as long as you've got a copy that purports to be what it is, and there's no real dispute over the copy, you don't need the original document. I don't even know we have original documents anymore because we e-file everything. And I was asked by a client one time to give them the original document of the affidavit that somebody signed in Missouri. And I'm like, I don't know how to do that because that was sent to me electronically. I e-filed that electronically, and then I received a certified copy electronically. So there was never any paper that was actually printed. So anyway, so those are common objections. I did want to say one thing real quickly about the drug testing. Here's a question that you need to ask yourself. Does the drug testing present, what is the picture from the drug testing? Do you have 70 clean tests, one dirty with the hair follicle that arcs over that's clean? So is it okay to say, let it all come in? Because you can then establish that either that UA was off, or even if it wasn't, you've got a history here that doesn't show addiction, right? So just because, figure out how can it help you, okay? Hope that made sense. Anything, Drake?
Just with the prior convictions, also remember that there is a ground for termination if a parent's been convicted or placed on community supervision. That includes deferred, right? For one of those listed offenses. So I will draw the prior conviction objection a lot, especially if I'm going for that ground. But the ground itself requires that I prove by clear and convincing evidence that they were actually, convicted of or placed on community supervision for that particular offense. And so just again, knowing your rules, knowing the grounds, knowing how to prove those grounds can help you overcome those objections.
Next slide, please.
So as far as objecting to the DFPS file, and I know at least in a lot of our child protection courts, there's discovery control plan orders that basically say you can ask for a copy of the redacted case file, the department has to provide it, and then you have to have special leave of court for any other sort of discovery. Just because it's contained in the DFPS case file does not mean that it's a DFPS record that can be brought in under the business records provisions. But because those files are made up of the collection of other documents. Whenever you do request the doc or request the DFPS file, you're going to get a redacted copy of it. So if you think that you need an unredacted copy of it for specific items in there, you need to be able to address that with the court, argue why you need a clean copy of the file versus the redacted file. And then object to the court making those, taking judicial notice of the facts in the file or findings in other orders. There's some real narrow ways or narrow, the court can take judicial notice of narrow things, but don't object to the court if they're trying to take judicial notice of actual facts and those sorts of things. Again, for DFPS practitioners, be aware of that. Just because it's contained in your file doesn't mean you're going to get it in through the caseworker because it's part of the case file. You need to have the appropriate witness available to be able to authenticate those documents. So again, if it's a medical record, having a doctor from that medical practice be able to come in and authenticate that document. A lot of times I'll rely on the redacted case file to say that I produced it, right? And so the other party has a copy of it. But then, I have to be ready to have a witness to properly authenticate it, and be able to actually introduce it as an exhibit during a hearing. All right, next slide, please.
All righty. So I'm going to go through the next couple of slides very quickly because I see we're pushing the time envelope and we've got a lot to go through. So objections, I'll let the slides speak for themselves. Basically, make sure they're timely. Read 102, read 03, the rule. Understand that the objection must be timely made. Pretty straightforward stuff. Stand when you're making the objection unless the judge gives you permission not to. I tried a case recently where the judge is like, don't stand throughout the entire trial. Address the judge, state the legal basis, avoid arguing the objection in front of a jury. So if you need to ask to approach, insist on a ruling. If the judge doesn't rule, then there is no ruling to the objection and there's no error committed. And remember, the last one is to preserve the record for appeal, have the answer to be struck, and have the jury instructed to disregard the answer. If it's an objection that is to the answer, because some objections, it's the questions that is not objectionable, it's the answer that's objectionable. So next slide. We're slide 19, Renee. Sorry, I was looking at a different thing. All right, Drake.
Yeah, so with making objections before trial, I mean, this is a good way to expedite things during trial. And so you can file a motion to exclude evidence, right? So this is going to keep evidence from even coming in, right? You can't even discuss it. You want to make sure that you file that motion as soon as you can. Make sure you notice the parties, right? Get it on the court's docket and be able to have that hearing. But again, this is to keep evidence completely out. Next slide, Renee. So this is different than a motion in limine, because a motion in limine is basically kind of bringing to the court's attention some of the things that you might ask for during trial, or some evidentiary matters that might be objectionable during trial. And so really it's just kind of, bring the court's attention to these issues and then say, hey, please don't allow anybody to discuss these issues until we're able to approach, get a ruling on it, and those sorts of things before, we go into it. I know the department has a very lengthy motion in limine that gets filed before our jury trials. And one of the, common matters that is presented is precluding or not allowing the parents or the parents' attorneys to be able to discuss how, the termination of the parent-child relationship is equivalent to the death penalty. And so we try to keep that sort of stuff out without, getting permission from the judge to allow it to come in. Because if the jury hears something, once that bell's been rung, you can't unring it. And so we want it to be, preventative in nature. Renee, if you go to the next slide. So there are some key differences between the two, and I've kind of alluded to these already. But motion to exclude, right, keeps evidence out, and that it preserves the issue on appeal, versus a motion in limine, which requires you to actually approach the bench, get a ruling on it before you can actually introduce it. It doesn't preserve error on appeal. So for a motion in limine, if evidence is introduced, you have to go through, you have to object. You have to state the reason for your objection. You have to get the court to rule on the issue and everything in order to be able to preserve it for appeal, just like you would any other evidence that you're trying to keep from becoming part of the record. So Renee, if we go to the next slide. So we're going to go into responding to objections. Like I said, we're going to go pretty quickly. I think we're running out of time here. But again, just know your rules, right? So if something is hearsay, know how you can overcome the hearsay objection. So is it a present sense impression, excited utterance, right? All of these exceptions in Rule 803, be intimately familiar with them. Just because something is hearsay, meets the definition of hearsay, doesn't mean it's automatically going to be kept out of the record or excluded from the record. So Renee, if you go to the next slide, it's just a continuation of more ways that you can overcome that hearsay objection. Judgment of a previous conviction, we kind of talked about already, as again being part of the D&E, and then also the other grounds for termination. And then next slide again, Renee. Again, these are just the being able to overcome the objection hearsay under Rule 804 with former testimony and dying declarations made by the declarant. Rob, anything you want to add to those? I know we're going quick because of time.
No, just read the rules, right? Okay, sorry. So these are statements that are not hearsay. So prior statements by a witness in a proceeding that was, under oath, and part of this process, right? Admission by party opponent's the big one. Just because a party opponent says something that's not necessarily qualifies as that, it has to be admission against that party. So that they said it against themselves. So make sure you know that. Not offer for the truth of the matter asserted. That's one that, is somewhat common enough that sometimes things are said, but it's not really for the purposes of, was Aunt Jane really there on Tuesday? Maybe if Tuesday's immaterial, maybe Aunt Jane showed up on Wednesday. Next slide, please. So this is chapter 104 of the Family Code. Don't have time to go through everything, but please read these sections and be familiar with these. The one that I do want to touch on is the next slide, please. So 104.06 is a hearsay statement of child abuse by a victim. It's the outcry statement statute. Be aware that it requires a hearing to occur outside the presence of a jury, and there is actually a criteria that has to be met to identify whether the circumstances of the statement provide sufficient indication of the statement's reliability. So be very aware that there's an actual hearing that needs to take place. Even if it's a bench trial, these are the qualifications. I've seen too many times where I've heard too many times where someone's like, it's a hearsay statement by the child of an outcry statement. It doesn't get in that way. You got to have that preliminary hearing to qualify that statement for it to come in. Next slide, please.
So again, we talked about the hearsay objections in the affidavit, so responding to them. Again, know the rules, know the exceptions. So there might be a statement made by a medical professional, but you can bring that in because the statement's made for the medical diagnosis or treatment. Again, planning is key in this regard as far as being able to get things in on the record. So know what is going to possibly draw those objections, how you're going to overcome them. If you have the witnesses available to testify, obviously that's going to be preferred rather than relying on the document. And then next slide, please. And this, again, something we've already touched on, but with regard to answering an objection to leading, asking a simple yes or no question is not necessarily leading, right? Leading has to infer the answer. So if it's just yes or no, and the way the question is worded allows them to answer yes or no. It doesn't necessarily mean that it's a leading question. Again, leading questions, it might just be a preliminary issue, right? Do you know the parent? Or how do you, those sorts of things? Yes, I know them. It may qualify as leading, but again, it might just be something that's kind of a foundational issue, and it, strategically speaking, isn't something you really want to or necessarily need to object to. If we go to the next slide.
So quick practice tips here. So responding to the objection. So the practice tip is don't fold to an objection. Basically, if the objection's made, don't run away from the question if you think it's important. If you can rephrase it, then do it if it's quicker to do it that way. But respond to the objection, know your rules, and have your case law ready. So be prepared to present case law to the court. If this is some evidence that's really, really serious and you need it in there, or really critical, I should say, then definitely be prepared to go argue that to the end. Next slide, please.
Yeah, and then just some practice tips, further practice tips. Again, state your response to the objection. I know we've gotten used to Zoom court, and so we don't stand because you'll go out of frame and those sorts of things. But whenever you're in person, you want to stand. You want to make sure you're speaking to the judge, not to your opposing counsel. If it requires a lengthy argument and it's a jury trial, you want to make sure you approach the bench, ask for a bench conference, and have it up at the bench so the jury's not going to hear it, or ask the jury to be excused in order for that argument to take place. After you've responded, wait for the judge to rule. If they don't rule and you move on, then you're not going to do anything to preserve your record. You have to have a ruling. If the court refuses to give you a ruling, then make sure that you object to that as well, right? Ask the court specifically to rule on the objection. And then if it's overruled and you're the attorney asking the question, usually have them restate the question or ask it again so it's fresh on the witness's mind. Next slide, please. If the objection is sustained, then, again, be prepared to offer it for maybe some other issue. I commonly will ask the judge, to bring the evidence in for a limited purpose. Usually I'll draw hearsay objections whenever I introduce the family plan of service. I'll ask the judge to, admit the family plan as evidence simply that the family plan exists and what the tasks and services were that they were to complete, and basically, all the other hearsay evidence, whatever might be contained. I'm not asking for that to be admitted for the truth of the matter asserted, right? So asking for limiting instructions or limiting the scope of the evidence, limiting the scope of the evidence, might be beneficial. And then next.
There's a practice tip. So one of the things that we put in here, there's 3 bullet points. The first is if you have a really broad pleading, an original petition, try to narrow that down so you know what you're actually trying. Think about a partial summary judgment on some of the grounds if you can't get cooperation, and narrowing it down to exactly what it is you're going to try. Be careful that you don't try any unpled matter by consent at trial. That happens frequently. I'm in the middle of a trial right now that actually is occurring. If a jury hears inadmissible evidence, the objecting party must pursue an adverse ruling. So here are the 4 steps to take. Additionally, the adverse ruling, O'Connor's 8-1 float, diagram 8-1. There's a flow chart there that's actually very beneficial. So take a look at O'Connor's TRCP's illustration, or whatever it's called, figure 8-1, and it'll give you a flow chart of how to pursue adverse rulings. So that can be part of your cheat sheet. Next slide, please. Okay, preparation before your hearing. Know your case facts and the exhibits. Anticipate objections to your evidence and prepare to respond. Attach a note to remind you of your responses to possible objections and prepare your witnesses. The one thing I want to say here on the prepare your witnesses, I tell all my witnesses, when you hear a question, pregnant pause, then answer. That gives me the opportunity to object if I think I need to object. It also gives the court reporter an opportunity to have a complete record. I also tell my witnesses, when you hear the word object, be quiet. Don't say another word until you're instructed to say another word, and don't ever try to get into, well, that's not hearsay. Don't argue the objection, witness. That's not your job. Next slide. Here's a form that a lot of us use, something similar to this. It's an element chart. You want to outline your elements to what it, even if you're representing a parent, you want to know what the elements are. You want to know the evidence that's going to prove or disprove that element. You want to know how it's going to come in. You want to know what the objection to that is. and you want to know what the response is going to be to that objection. So think ahead, and be prepared to go. Next slide. Offer of proof. Okay, we're close to time running out. So offer of proof. So the offer of proof essentially is when there's an objection, it's sustained and you can't introduce evidence, you're going to ask the judge that if you can offer the evidence, or you're going to want to offer the evidence outside the presence of a jury, or if it's a bench trial, whenever the judge is available for you to do that. So you can do the offer of proof. Next slide, please. You could do it by calling the witness, going through the Q&A like you would with the witness, and make a record of that testimony that's going to be excluded. You can also do it by telling the judge what the evidence would have been and make sure that's on the record too, and that would preserve it. I see the offer of proof as the last opportunity to allow the judge to be able to maybe reconsider their decision as to why the evidence should be included and not excluded by the objection. So if it's important enough for me to make an offer of proof, I typically want the witness to testify, because I want to hopefully get the judge to a point where they go, okay, now I know why it's here. I see how you can overcome the objection. I'm going to allow it, one last chance to actually put it into the trial record and have the jury consider it, or be a part of the evidentiary record for the judge to consider their decision. So that's my preferred method. Next slide, Pete, please. Oh, I'm sorry. Next slide after that one. I was already talking about those two.
All right, so the other way that you can get evidence is with a bill of exception. I will note that these are extremely complicated. They can confuse attorneys, they can confuse judges, because they're really just not used that often. But a bill of exception is a way that you can complain on appeal, right, about an issue that doesn't or isn't part of the court's record. So for whatever reason, let's say, there's a Zoom trial or a Zoom hearing and it wasn't recorded and there wasn't a court report or something along those lines, and you want a record of the evidence that was presented or would have been presented in that hearing, then this is the way that you make it part of the court's record in order for the appellate court to be able to see it and consider it. If you are going to seek out a bill of exception, it has to be filed no later than 30 days after your notice of appeal is filed. And again, it's part of the clerk's record rather than the reporter's record. And next slide, please. Bills of exception, they're very technical, right? So you need to look at Texas Rules of Appellate Procedure 33.2, read through it carefully. If you have Westlaw and you have access to the secondary sources, you can actually get about an 8-page or so guide to Texas Rules of Appellate Procedure 33.2 to kind of help you go through that process. But again, it's technical, it's complicated, can be very expensive depending on the hearing and the trial and the types of evidence. One thing that you will notice in those rules is opposing counsel and the judge have the opportunity to weigh in, right? Because again, there's no record of the actual event or of the evidence. It was off the record for whatever reason. And so this is the way that you get that part of the court's record. And so opposing counsel and the judge get to weigh in about what was presented, what was said, what was, ruled on, those sorts of things during the period of, not having it on or not having a formal record. Next slide, please.
So we're towards the end. So these are some helpful resources. We've talked about the toolkits that the Children's Commission puts together. Of course, those that practice family law are familiar with the Family Law Essential Toolkit. There's some good stuff there too. I get no money from this, but the Handbook on Evidence by Professor Good and Wellborn, to me, has always been a really important book to have. It's becoming really expensive, so if you want to spend $800 or so for it, it might be worth it. But it actually lays out objections and responses and things like that. So and has tons of case law that's incorporated into the commentary. So those are just resources that you can use to be prepared for trial. Really, at the end of the day is preparation, preparation, preparation. You know, Broadus Spivey had a sign over his desk that said, more important than the will to win is the will to prepare to win. So just prepare.
Right. We are a little bit over time, but I do want to thank Rob and Drake for their excellent presentation. We do have a couple of questions that we will make sure to pass along to our presenters, and we will make those responses available on our website. I did just briefly want to at least provide one of those questions to you all. And so that would be, what is the best way to object when the court asks a gal or an ad litem to give their report after all sites have rested and closed, and the report contains hearsay or assumes facts not in evidence?
I, from the department's perspective, probably aren't going to be objecting to it because I'm assuming that they're probably supporting my position. But
so I would ask if the court is reopening the evidence. That's what I would understand the court to be doing. So I'd get on the record and make sure, Judge, I just want to understand, are we reopening the evidence here? And am I going to be permitted to cross-examine on these issues? And I mean, I can't imagine a judge going, no, we're not reopening evidence, but I'm going to admit evidence after it's closed. And no, I'm not going to let you to ask any questions. I mean, I've never had a judge do anything like that. So, you know, trial judge is never wrong till the appellate judge says they are. So who knows, but that's what I would do.
Thank you. So again, we do have quite a few questions, and we will get those responded to and provide them on our website. We hope that you all will join us on April 24th for our next webinar, which will be focused on benefits for older youth in care. Registration information for that course will be added to the Children's Commission On Demand webpage and will be sent out via email resource letter later this month. Thank you to everyone who has joined us for today's live webcast and for sticking around with us as we've gone a few minutes over. The State Bar has approved this course for 1 hour of MCLE credit. Additionally, the Texas Board of Legal Specialization has approved this 1 hour course for certification and recertification requirements for attorneys and paralegals in the specialty fields of child welfare law and family law. Individuals who are watching this replay of the course will contact CC Training at txcourts.gov for MCLE self-report information. Once again, thank you so much for joining us for today's presentation, and we hope you have a wonderful rest of your day.